Hi, everybody. Again, it's great to see some great faces and names here that we've had in the other sessions. So I'm pretty happy to have you all here today and taking the time out today. Matt Trotta, thank you also very much for attending. Matt is from Field Law and is one of our preferred partners that we've worked with for many years. So thanks again, Matt.
Hey, thanks for having me, Matt.
Perfect. So today what we're going to do is discuss obvious tips and tricks that you can do today that costs you practically nothing, that you can do right now to save your estate money and hassle, not only for your family, but for your executor and for us too that's helping you settle the estate. So we're going to go on to talk about those tips right now. So the first one, and we're gonna, by the way, we're gonna stop in between a few slides. So we're gonna talk about accounts first, a lot of the registered accounts first, and then we're gonna stop and we're actually gonna take questions all in between this so that as we go, you can kind of ask your questions on some of these things that you have as they come up. So we can kind of make it more conversational today is kind of our goal. So the first one is obviously talking about designated beneficiaries. Because many times in our career, you see problems not only with the will to somebody who set up an account. So obviously, when you have RSPs, you should always have a designated beneficiary. What a designated beneficiary says is if you're a qualified spouse or you're somebody who's financially dependent, or you also are disabled, you qualify as a designated beneficiary that you can have an RSP rollover to. It doesn't always contain your kids. So that's, a lot of people get that really confused, but why you want to do that is because if you have a designated beneficiary, that RSP can then roll tax-free to them, which is really important from a tax perspective, because what a lot of people don't take into perspective is they're like, well, I want my kids to have, let's say, $300,000. So I have 380 in my RSPs. I'm just going to split it between my 3 kids. The thing that you have to take into effect is the fact that you're going to have to pay tax. Your estate is still responsible for that tax. The RSPs will go straight to your kids. So, but your kids don't owe that tax bill, your estate does. So if you have no insurance in your estate or other assets in your estate or charitable donations to actually offset that tax bill, that becomes a real problem. And we also want to make sure that your will, matches that. And you probably have seen that a lot, Matt.
Oh, absolutely. It's one of those nightmare scenarios that tends to happen on smaller estates is you have a situation where the majority of the assets are an RSP or a RIF, and it moves outside the estate, usually because somebody was given advice that it's easy, you'll save on probate. What ends up happening is there's a deemed disposition on death, and the tax bill shows up in the estate. It shows up in your in the last T1 return. And then from there, the fun begins, because either the estate doesn't have enough money or the estate is completely drained after payment of funeral expenses and administration and testamentary costs that courts have recognized are reasonable. Then you have a bunch of angry beneficiaries going, well, hey, the will said I get the residue. Where did it all go? The other fun thing that often happens, and I've dealt with a couple times now, is the estate becomes insolvent and CRA starts looking at who should pay. When that happens, the beneficiaries are actually jointly and severally or solidarily liable for the amount of the RSP or RIF that they received once the estate files its return showing that disposition occurred. From a civil point of view, you get into a bunch of arguments of whether or not the estate can actually pay for it, or if it's just trying to protect beneficiaries or to keep money for a different creditor. But if not, everybody has to kind of dig deep, and CRA gets to pick and choose out of that to an extent. And long story short, it's going to create a lot of bad blood. It's going to take a relatively simple estate and make it very complicated.
And I think we've seen that as well in our offices, even with a small estate, Matt, like you were saying, became insolvent. And all of a sudden, it's like the only asset she had left was a father's van. And she ended up having to sell the van to pay CRA because the RSPs went directly to her, and then they owed some money, and there was at least enough money by selling the van. there was nothing else in the estate. So I think people have to be definitely aware of that. The other factor that I put down here is segregated funds. Is not all RSPs, if you're in securities, you still have to get probate most of the time because it's over a certain amount that you have in your RSPs. Segregated funds will bypass the probate process. So that kind of helps you if you're in that area where you kind of go, that's really important to me. I don't have a lot of assets and I want everything just to bypass probate so that I can save a bit of money. That's obviously something you can contemplate for your estate and talk to us about. Okay, we can go on to the next slide. So the next one, of course, like I also mentioned in the other one, is you may have group plans, you may have what's called deferred pension plans, you may have deferred profit sharing plans. Make sure you have beneficiaries on a lot of those, because we see people who are like, oh, I didn't even know my work one had one, or gee, I forgot about it altogether, or they haven't set up, they've moved accounts and they haven't set them up properly. We, just recently met some new clients as well, and, they set the beneficiaries up on one account and didn't for the other spouse. So that's something that you always have to watch, because not always do advisors, not make mistakes. You hope that they never do, because you obviously want to come to people that know what they're doing, but sometimes you have people who don't know what they're doing, and that happens quite a bit. But prescribed waivers are an interesting thing on locked-in funds, and also with pensions, this comes into play. So a lot of times it's like you can be in different jurisdictions, and let's say that spouse has signed a waiver for that pension. If you passed away and then you got remarried or you revoked it, then that person wouldn't get the money. But a lot of people never remember what they did 20, 30 years ago, and all of a sudden we're in retirement age, and they were married to Susie a long time ago, and Susie, was a really great person. She didn't sign off the waiver on the pension, and she didn't sign off the waiver on the locked-in account. Then all of a sudden, he's married to Doris, and Doris is a great person, and she's really wonderful, and he's going, well, in my estate, it's going to be a really great thing because she's going to get my pensions and she's also going to get my locked-in money. Well, you know what? Susie never signed off on that, so Susie actually gets the money. And that's something that people should always be conscious of. And as well, we've seen people too that they don't realize that, a lot of times when people get the pension forms, we have our clients come in and sit down with us and go through their pension forms and say, what's best for you? A joint and several pension, a life pension. Sometimes people choose a single pension because they're like, I need that extra cash right now. Maybe they pick a single pension and self-insure and get some insurance to offset it. That's obviously a way that you can still get the money to your spouse. But if it's a life pension or a single pension, that's something that your spouse isn't going to get on your death. And I think that's really important. We're actually dealing with an estate case with two sets of parents that, she looked us squarely in the eye and said, oh yeah, when he dies, I'm still going to get these pension payments. And when we met with the spouse and the new wife, there was no guarantees on that pension at all. And he checked when he got remarried, and he's like, no, there's no guarantee on that pension. She won't get the pension payments anymore. So someone who's living off of those pension payments at $1,200, $1,400 a month, it's a rude awakening when all of a sudden, if that person dies, and that person is ill. So of course it's like that person's likely going to pass relatively in the next few years, and you kind of go, that person won't have the payments to do the things that they want to do right now. So we made sure that, the family knew, and those are things you always want to check. And if you don't know and you can't remember from years ago, those are the times that you kind of say, make sure you do. And some also have a death benefit that will pay out regardless if you picked a single. So it's always keeping some of your paperwork too, because I know people have gotten into shredding now, and you want to make sure you keep some of that paperwork, because sometimes it's hard to even get tracked down from the companies. And Matt, what have you seen with that?
So I think I can kind of sum up most of my experiences in one statement, which is don't think the legal documents that are prepared for you are the end of the story. And to kind of get into detail, I've had a few files where there have been cohab or prenup agreements where somebody is explicitly agreeing not to take on a pension, but if you forgot to take them off of the actual pension plan, well, now we have an argument, and now it's going to get expensive, and practically speaking, that person's probably going to end up with something just to make them go away, or we're going to be spending a huge amount of money in litigation. So just because your prenup or your cohab says somebody isn't getting something, that's not the end of the battle. Same thing, I would say, don't rely on a will. We often will do that in planning. It's meant to be a backstop. We'll reference, if there's a pension plan and there's an issue with a designation, the proceeds are to go here. It's usually intended for when the pension plan has the estate designated as a beneficiary, that we then direct how that money is supposed to go. But if you think it's the end of the story by putting that designation in the will and not actually changing your pension, you are inviting some complication. The two documents should always match.
Yeah, I agree. And the other thing to think about is that if you have a disabled child, that's something else you can do is put a spouse on as beneficiary and put the child on as a contingent beneficiary, that if both of you passed away at the same time, that actually can be done with most of the insurance companies. So definitely something to look into with that kind of stuff too, for insurance or for seg funds. That's all done through insurance companies. So that's also something to think about. Okay, we'll go on to the next one. So TFSAs are a really tricky one. And when we often ask people who come to us new, they're like, oh no, I set up a beneficiary. And it's like, well, did you set up a successor owner? And they're like, I don't know. What's a successor owner? And the majority of the banks, I would say 90% of the time, I have seen no successor owner at any of the banks. So this again comes with experience. Is obviously a successor owner will transfer the TFSA to that person, as well as you get all the room intact. So if you're just a beneficiary, then you'll get the money. So if Susie has $50,000 in her account when John dies, and John has nothing in his TFSA, she'll get all of John's TFSA if he had one, and all of his room. And if he doesn't have one, she gets all of his room. Or if he has a small one, she'll get all the room plus the small one. So that's something to always have on there. He has to have a TFSA set up to get the money, and the room. But that's something to really consider, especially if you've got a small amount into a TFSA. If you don't, and you just have a beneficiary, make sure you change that at the bank. And again, TFSAs are difficult that way.
Mm-hmm. Absolutely. With the same sort of principle applies. Don't count on the will to speak to these things, because you're having to speak the bank's language, and the bank is going to follow their forms first and follow the will second. Again, ideally the documents mirror. So if you have a successor owner, the will doesn't contradict that or doesn't get into any sort of confusing language on that. The will just designates the beneficiary if that original one fails or mirrors the language. But typically, you want to make sure that your documentation with the bank is accurate and up to date.
Awesome. And this is kind of the end of our registered accounts. We could kind of talk about non-registered quickly. As non-registered will go wherever your will says it's going to go. But if you have a seg fund, that's sometimes where, let's say your family hates George, and George is, a black sheep of the family, and absolutely you're worried about when you die that George is not going to get his $5,000 because the family all hates him and it's going to be a big fight. That's something that you could do in a segregated fund, and it actually, no one can find out about it. Same thing, you could put that into a trust, and that's a way of getting the money to George that people don't necessarily have to find out about, and it will go straight to George, and you can set up a beneficiary that way. And so that becomes really quite popular and easy to do through a seg fund, same thing, or through a trust, if there's enough money there for a trust, of course. Those are things that are really important too to consider when you're contemplating these type of things.
Mm-hmm.
So we'll open it up to questions. If everybody wants to go to the chat section or the question section, or even put up their hand, and we will unmute you, and you can ask some of your questions if you have any on this one section, and then we'll keep going.
Hey everyone, it's Jeff from the Tower Group. Like Pam was saying, if you have a question, just put it in the drop down and we'll get to that right away. We do have one question from Brenda, and she's asking, how come TFSAs have the option of successor owner and my other registered accounts don't?
Good question, I guess, really, because the government says so. That's, you know, that's actually what the TFSA legislation was set up with. Just because I think when they originally set up that legislation, it was kind of meant for people to be able to take money off registered assets and put it into a tax-free savings account for any excesses they didn't have. Um, so, you know, that's really what I've seen because it isn't available on RSPs.
So it's actually a very similar principle when you break it down. With an RSP or RIF, you have a tax deferral between if you are able to give it to a spouse or a dependent grandchild or child or somebody who fits that rollover description, like Pam mentioned earlier. And on the second to die, you have your tax event. Because this is a tax-free savings account by its definition, how it works is kind of the same way. If you have a spouse who qualifies as successor, it's rolled over with that space effectively. And then on the second of you to pass, anything future now has has lost its status that's been given to it under the Income Tax Act. So it's sort of a similar principle on that. Mostly because the TFSA doesn't have a tax event that's coming because it's set up with after tax money, where an RSP or a RIF, you have an offsetting deduction when you contribute, and then you have your tax event when it comes out.
Great, thanks. Our next question comes from Raymond. He's asking, what happens when a beneficiary can't be reached, or if they refuse for an RSP or in the estate?
That's an interesting one. We have had that happen, and not only can the company keep it until they've found somebody or until the will is actually, you know, looked through, you've done the probate, you've done everything on the will that you finally say, okay, now I've got to move these assets. I can't find this person. Then Matt can kind of talk about what happens from a legal perspective.
Right. So this is one of the reasons why we have in the will clauses on tax deferred assets and registered plans and whatnot is if the designation fails, it will then direct that it goes into the estate and it's dealt with in that way. So how we practically get there is going to be dependent on the bank. Like Pam said, we need to have a grant of probate for the bank to be able to deal with the estate on that. And if there's a clear repudiation or renunciation of the gift from that intended beneficiary, it's a little bit more straightforward. If the beneficiary is missing, then we have to go through the steps to kind of verify that they're missing. And that may take a substantial amount of time before it can then enter the estate, but it'll depend on the policies of the specific plan.
Thanks. Next question comes from Steve. He's asking, you often hear that you can't inherit debt in Canada. However, with respect to your RSP comments, it seems that you can when it comes to tax debts. Any additional comments on this?
Yep.
So it's true that a beneficiary doesn't inherit debt in almost every case. What you're inheriting isn't so much debt in a situation of an RSP or a RIF. It's a tax liability as a result of money you've received. So it's kind of like any other taxable event. And this only occurs if the person who triggered that tax event is unable to do so because you have received the benefit, and therefore CRA has a place to go get the money that would have received otherwise. In a lot of cases, though, your executor can certainly inherit some debt, and executors have to be very careful on how they distribute assets. So if they have this hypothetical situation where the estate became insolvent because the main asset was the RSP, and they're sitting with this negative balance, the absolute worst thing they can do is start giving money away to other creditors because they think, well, you know, we're in a sinking ship if I try to reduce the amount of creditors, because if they're not doing it appropriately, if they're satisfying unsecured creditors, or they're not using that money for administration, testamentary, or funeral costs, what they're doing is they're painting a giant target on themselves. and then they have therefore inherited the debt of that deceased person. So, but from a beneficiary's point of view, it's almost always they receive their gift after the payment of taxes, debts, expenses. It's only in the case of something like an RSP or a RIF where they're not really inheriting debt because they've inherited the money. It's the money less the tax that ought to have been paid.
Thanks, Matt. So that's all the questions that we have at the moment. We'll open it back up towards the end of the presentation. And Pam, I'll let you take it from here and we'll move on to the next slide.
Perfect. So the next one is still a registered plan called an RESP, which is an education savings plan. But this one's a little bit different because this one's for a child, usually, or children if it's a family plan. What a lot of people get confused about is this is a trust and it's going to automatically go to my children. And I know Matt's been doing a big paper on this and had to do a thesis on this and things like that. So he'll be able to talk a lot about this. But I think from our perspective is we always tell people the subscriber is actually the owner of the account. If there is no, joint subscriber, and oftentimes we try to put people on joint, sometimes they're on singular. And again, we want to make sure then that either we put it joint or that we have a will in place that actually says it's going to be left to the kids. Otherwise it's left to the estate. And a lot of people don't realize that is it'll go into the estate and get split between everybody who's on the will. So we always, and I see this a lot where absolutely, the wills that come in to us, they have nothing on the RESPs. And there's a lot of not only grandparents that have RESPs for kids, but also parents that have a lot of these already. And you can talk more about this, Matt.
No, absolutely. RESPs are very interesting and very, what's the word I want to use here? Potentially problematic structure because they're interpreted in different ways for tax purposes, estate purposes, and family purposes. So it's correct that an RESP is not technically a trust in every way, shape, or form, but they can be treated that way by our courts. So if you have a situation where an RESP is dragged into a divorce and let's say somebody dies halfway through, the question of whether or not the RESP funds are matrimonial property is a wait and see usually from our courts. So they'll say, well, if it's set up for the benefit of the kids and it goes to the kids, then we're going to treat it like a trust. If it goes back to you, then it's not a trust anymore, and now you have to pay out to this other person. So they can be very tricky in that regard. As Pam mentioned, they can also be really tricky if we don't have a successor subscriber clearly listed, and if we don't direct the executor on what they're supposed to do when they do become it. So in a lot of times we'll have provisions that say the executor becomes successor subscriber, the beneficiaries are the same, or we may even say the beneficiaries are no longer the same. It's also a new class of beneficiaries that we want to do. And that depends greatly on what a client wants to do. Most of the time, I'm more comfortable saying we keep the existing framework that's in place and the executor just administers it. But in any event, it should be brought to the attention of the planner and dealt with properly and not just kind of, well, there's general powers. And a lot of drafters will just rely generally on Section 20 of the Estate Administration Act, which says anything that you could do in life, your executor can do in death. But practically speaking, specific language is always better because you've got a potential conflict between tax law, trust law, estate law, and family law. And so you want to have, the ammunition in place to be able to deal with those as effectively as one can. There's no such thing as a 100% solution because the laws are always changing, and sometimes interpretation is really in the mood of the justice that morning. So it's one of those things that more specific language is better, but we try to plan to be as predictable as possible.
And have you seen many situations, Matt, where let's say parents get divorced and they want to keep the joint RESP together, yet they both have completely separate, different kind of wills that direct different things?
Fortunately, I've never had to plan for that, but I have heard of that happening before. Whispers from family lawyers and the chills running up my spine were palpable. But it's something that does occur. in a situation like that, it would likely be the last to die's will who would dictate how it works out, because most likely if they're keeping it joint, it's the remaining person becomes a successor subscriber, and then it would be whatever the will of the last person has to say. So joint works really well in theory, but it just kind of goes into my general mentality about dealing with blended families, which is you're leaving a lot to chance if you don't have it segregated out. And even then, you may have it in your mind to have the same end beneficiaries and the same goal, but as life happens, a lot of times people will inherit new legal and moral obligations if they get remarried, if they have another child with somebody else, if they decide to adopt a subsequent child. New obligations apply, and would it be fair for them to exclude those new equal obligations to them, but strangers to the other person into these things? It's a subjective argument. The courts would likely say, well, you have an obligation to them, ... Where that ... goes could be anyone's guess, but the joint things don't always work so well. So if I was planning, I would probably try to dissuade them from that.
Awesome. Thanks, Matt.
Yeah.
Okay, so now we'll move on to the next section. Do we want to open it up to questions just on this one topic? I know there's quite a few people with kids on the call. We may have some questions on just that section.
Yeah, definitely. We can open it up. At the moment, we don't have any in the queue, but if everyone has one, feel free to type one in and we'll address it right away.
Perfect. Okay, doesn't look like we have any. Okay, so we'll move on. The next steps, obviously, to developing an estate plan is oftentimes people come to us and go, well, why do I have to list all my debts out? Why do I have to list all my assets? And this is, we were laughing because we even had a conversation with an older client yesterday that one daughter's kind of had enough right now and the other one's trying to deal with it. But when you have somebody, let's say, who could have more debt than they do assets, that becomes a problem when doing the will, because of course then we are dealing with estate insolvency and potentially walking away from homes or dealing with that kind of stuff. And it's really important that not only does a planner need to know that, but a lawyer needs to know that. And a real estate agent even needs to know that if they're going to be trying to sell the house, because you have to pay them. And at the end of the day, if there's absolutely nothing, it might be better just to walk away, period, and let things foreclose, deal with everything that way. Because a lot of real estate agents can't even from an ethical standpoint take that on either. And I think that's something that people often forget, or they put down an extensive amount of assets that they feel that their things are worth, and downsize the amount of debt that they feel that they have. And that is common, that we see all the time, that when we come down to it, it's like, well, no, you have this, you have a mortgage, you have. So these are things that you have to consider. Is a lot of people think that they're worth $1 million, but it's like, well, no, you owe the bank for your home, and you owe your car, you owe this and that. And often those things, especially at 50 cents on the dollar, sometimes, especially if you have a company and people think their company's worth a lot, but all of a sudden without you there, your company may be worth very little. And all of a sudden you're not doing the same business, the banks will call in your loans. So those are things that we always need to look at, and we always do net worth statements and things like that on people that have that. But I think it's super important that we have that listed out. And you can kind of talk a bit about that too, Matt.
I think that's really good points. The one I see a lot is the breakdown in value of the private corporation. Like a lot of professional corps, a lot of personal services that are offered through corps, they lose most, if not all, of their value when they lose the key person, because that's the source of your clients. That's the source of the service that's being provided. And in some cases, the client list may be portable. And I've worked on a sale of an accounting practice where that was the case, and there was a reasonable amount of money that was able to be paid for the practice. But I always wince when I see an estate that has down to the penny what they want to give to people, because they're convinced this is what I'm worth. Well, no, you're not. Knock about 30% off of that, I even sometimes tell people knock half off of that, just as a, say a situation happened like what's happening right now. You have a pandemic, stocks drop 20%. Maybe you have some bills, then you have some taxes because you've had these securities for a long time. So even though you lost 20%, you still have a substantial capital gain. Then you have to pay lawyers, accountants, whatnot, and then you have this estate to administer. And if you had $100,000 here and $500,000 there, and all of a sudden at the end of the day it's not worth that, you're asking for trouble. So typically, I recommend when we're doing planning to keep the specific gifts to about 25% or less of the value of the estate to allow for significant fluctuation. But also to be honest about what you have for debts and assets and what things are really worth. So tax assessments from the city are historically not bad for planning because they tend to understate. Right now, we'd even want to ignore those and go even lower. And this is one of the situations where it really pays to be a pessimist, because you're not going to be caught off guard quite the same way as if you're an optimist when it comes to planning. And so when you're developing your plan, some of the things here on this screen are essential and have to be done with a critical eye, not just putting down things. So a list of desires with your family. Look at this critically. If your kids don't get along super well, even though you think they kind of do, be honest with yourself and realize if they don't, let's not set up a situation where they're running an estate together, where they're being asked to exercise their discretion to decide how to allocate personal belongings, things of that nature. Or in a blended family, it doesn't matter how well stepmom and stepdad get along with kids. Is it a bright idea to thrust them into a situation where they're having to make subjective decisions? Probably not. And that's something that you can kind of look at critically and pessimistically and cynically right off the blocks, and potentially save yourself, or your estate rather, tens of thousands of dollars down the line.
Yeah, and I agree. A lot of people don't discuss their wishes. So then all of a sudden, we've seen a few fights even just on the cremation versus burial, and they're like, I really want mom and dad cremated. I don't, we had a car accident and they went off the road into a ravine and then into a lake. And of course, it's like you had the fighting between the kids of how mom and dad were going to actually be either cremated or buried. And it was such a fight between the kids that it held up funerals. And I think if the parents had a discussion of what they would have liked to have seen, and, from even that perspective, or pre-burial, or, looking at that kind of stuff as to what they really want, because I think that's super important too, to, talk to your family about. Or if you, not that you can write in a will that, hey, you want to be shaken over the ocean in Hawaii. You obviously can't do that if you're in a will, because you're not actually allowed to be taken somewhere and, to the top of Everest. You're not allowed to actually do that, but lots of people have. It's just, that's going to be your discretion, that you're going to be talking to your family about those type of things. And you can kind of talk a bit about that, Matt, too.
Oh yeah. Yeah, you want to be really honest with yourself about these types of things. And if you have some strong wishes, or even if you just have some strong wishes of what you don't want to see, sometimes these can go in the will, but a lot of times they need to be discussed with the family, and to make sure everybody's on the same page. You don't want a situation like one that I had to be a part of, where we literally had to separate mom in a boardroom at the law firm because they wanted to equally divide the ashes, because they didn't want to have one person carrying that. And I can almost guarantee that certainly wasn't what mom wanted, but everybody's hands were tied. And now you're paying lawyers several $100s an hour to do something that, is pretty morbid when you think about it. And so these kind of extreme situations serve to show that being critical about these things and being realistic about what your own personal family situation is like is pretty important. And it's something that a lot of people will kind of gloss over when they're doing their plan. They think about who's going to get my money. and who's going to be the executor, and that's about the depth of it. Or realistically, disposition of remains, disposition of assets, or not even assets, of property of a high sentimental but low financial value. Understanding your family dynamics and making sure it's set up in a way that your executor or attorney, if you aren't passed away yet, can understand and appreciate, is worth its weight in gold down the line.
Yeah. And, so the next one kind of plays into the insurance as well, but considering tax consequences, position and disposition of assets is a lot of times people will have a private corporation like Matt was talking about earlier, and all of a sudden, those assets don't flow out of that private corporation tax-free. Those assets, usually depending on how much you have, can usually flow out to family at 30% tax. Your insurance can be applied for through the CDA account, but there also is a calculation that comes out to your family that can come out tax-free to your family. But of course, that kind of plays into, is your insurance in the right place? Are we analyzing what the companies are worth, what they're not worth, what assets are held in the companies? Because a lot of people do hold a lot of money inside their companies. So then all of a sudden, when you're having to pull it out and wind it down, there's a taxable consequence there. And a lot of people also come to us and, sometimes they want to go to a bank and they have, they're trying to sell a cottage and they're trying to, get rid of things like that. But if they died tomorrow, they still have the cottage, they have their residential home, and they have RSPs and a pension. And it's like, that is the most taxable situation in the world. And you definitely would want to have insurance. A lot of people kind of look and go, well, I'm going to get term insurance. Well, term insurance doesn't last forever. Some insurances last till 80. So all of a sudden, if you die at 81 and you don't have insurance coverage, that's something to think about. But as well, your RSPs grow tax-free while you're in retirement. If you're using your RSPs by then and you're using quite a bit, well, that value might have gone down. But that's really where cash value comes into play, that if your company's going up, your rental property is going up, and all of a sudden you've got your RSPs that are increasing in value and your pensions that maybe haven't gone down that much yet, and that's increasing in value, that's really where cash value policy will really benefit you, because then you have that for life. You have that to pay your tax bill, which, a lot of people don't really consider, because it's like, well, your RSPs are going somewhere else. I'm going to leave my cottage to someone else. Well, that's all taxable, and your company's all taxable. So make sure you have something to pay that tax bill, because all that stuff's going to leave. And then people are like, well, they could sell my home. But it's like, what happens if you're in a market like this with COVID, or even, Alberta for the last 3 years? It's been tough to sell a house. And so all of a sudden, when you're fire sailing a home to try to get rid of it, to try to pay the tax bill, it gets pretty intense, because CRA is not going to wait. And they're not going to wait 3 years for you to sell that house. And if they have to, then they're going to charge you massive penalties. The penalties are outrageous, as well as interest. So really, this is where your insurance plays a huge role in your estate plan.
No, absolutely. And when you said private corporations and you said 30%, a little voice inside my head went like this. Because you have your capital gain at death, then you have a deemed dividend as well. I mean, you add up the two of those together, you could be looking at an effective tax rate of closer to 60% on some corporations. So it's really important. We plan for, planned and unplanned business departures. And, one of the things that people can do right now is, you look at your private corporation, you look at the kind of earnings it may have, you look at what your future of it is going to be, and maybe it's a good time to do some tax planning now. You might want to do an estate freeze to crystallize the value of your company into preferred shares, put the growth into a trust. There's a lot of different ways you may want to go about doing it, because the idea is, if you have a planned or unplanned departure, that we currently have ways to play around with structures so that we don't end up with that double tax hit. But the way that the government is going, they're leaning towards taking away the really good solution and leaving us the one that still ends up with about a 30-40% tax hit versus a 24% tax hit. The idea being, you may have heard the concept of a pipeline plan or a 164(6) loss carryback. To get overly technical, those are the two main ones that are used for postmortem planning. But it certainly helps the situation when you're able to do some planning in life, take some things out of the estate, take some things and maybe redeem them at a different tax rate. You have a lot less options when you're an executor looking at the administration of an estate than you do right now. And sometimes a few $1,000s spent on a tax reorganization now could save several thousand in tax later down the road. So that's something that, again, with that open eyes, a will isn't the end of the story, especially with a private corporation, as a lot of doctors and other professionals are starting to realize, the government realized that that was a good way to help you save into the future and plan for your retirement. And they've started attacking these with higher taxes and reduction of benefits under the Tax Act. Maybe there's some other structures in place, and there's structures that my tax team and I will use for professional corporations to help them extract their return, their earnings in time, so that we don't have as much of a hit on a post-mortem point of view or an unplanned departure down the line. So these are things to talk about with your tax accountant and your tax lawyer as well.
Yep. And the other thing that people need to think about is how different jurisdictions affect your plan. Because I don't know how many, people we come across with property in Palm Springs and property. We had a death with property in Hawaii, and they were shocked that, there's 45% of the value of the house gone when they passed away of their property in Hawaii, and they hadn't taken that into consideration at all when it came to their wills and their planning. So again, US tax, very different. That could be a whole other one presentation that you could do on US properties and US estate tax, because of course that's quite a bit different, as well as BC is quite dramatic. Same with Ontario is quite dramatic. So if you have that Muskoka property or you have that, property in interior BC, really important to think about the taxes there. And you can talk a little bit to that too, Matt.
No, absolutely. Once you get outside of Alberta's borders, you're looking at a different ballgame, whether you go north, south, east, or west. Saskatchewan is similar to Alberta in a lot of ways, and anywhere in Canada will recognize a Canadian will. Most anywhere in the United States will recognize a Canadian will. So it's not the fact that your documents don't work, it's that your documents don't work the way you want them in some cases to work. And had you had jurisdiction-specific advice or jurisdiction-specific planning. And in a lot of cases, before the property is acquired is the best time to do these things, because once they're locked into a certain structure, it may be a hit to change it to something that would have been more advantageous. But even then, even if we're not dealing with Captain Hindsight in advisors saying, well, you should have done it this way, it's still important to have that jurisdiction-specific advice, to avoid a situation where, you've allocated a percentage of your estate to a professional executor to find out that they can't actually operate in the jurisdiction that you hold some property. And, in some cases, people don't always tell their professional executor that subsequent to the setup of their documents and their appointment that they've acquired property in these jurisdictions. You have situations like in BC where you have land transfer tax and you have their probate tax, and it can be a double hit on some of these things. And it may not make sense to have a situation where you have an estate take the property, it goes into a trust, then it gets split into other beneficiaries, or a situation where there may be multiple transactions that occur. Where in Alberta, you pay land titles fees, and you just have to kind of keep an eye on foreign ownership of land provisions that exist. And there's situations like that, but different rules than in BC, different rules than in Montana. And it's one of those things that you can't do the buy one, get all 50 states free sort of advice. I work with a U.S. tax attorney. He reminds me that on a regular basis. I went to a U.S. law school, and there's a reason I'm not called in a U.S. state, and that's it's complicated, and every state is different. There's a uniform code on a lot of the major provisions in the United States, but everybody's enacted it a little bit differently. So if you have property in Florida, seek a lawyer or an accountant in Florida to be able to determine these things. And don't cheap out on the $500 will and the H&R Block kind of accountant who says, oh yeah, I'm pretty sure it's like this, because the cost of not using that advisor at the time will be staggering later, because it always costs more to fix than to prepare.
Yeah. And I think, you know, we'll probably do one session on cottages just because I see it in what I do. And I think that is a whole one session. But that's something in here too that, you know, is something to consider when we're talking different jurisdictions, especially if you hold cottages that were dad's cottage, let's say, and we're splitting between 4 brothers and a sister, and then they bought out the sister for, you know, 20,000 when the cottage was probably worth $500,000, and they're like, oh, we're just going to give you 20,000 if you want to get out. All of these things become taxable on another death here along the line, because CRA will actually look at a market value and what you've done in the history of it. So don't think that you guys can all make your own rules and, you know, do your own accounting, and you guys don't have to claim that taxable capital gain because it was just a sale between family, because I hear that so many times. And please, it's like, no, you have to get accounting advice on that. You have to claim it. And yeah, you have to do market value, even though you guys have decided not to. Somewhere along the line that ends up catching up with you and biting you in the butt. So like Matt was saying, is that all gets caught up on the estate.
Oh yeah, and CRA is getting better and better at this. I mean, there are, you know, some people who have the old school mentality of CRA can't reassess what they don't know. That has very abruptly been coming to an end over the last 5 years with the advent of further information disclosure. They have an increased use of AI when they're reviewing returns and doing audit analysis. There's going to be a greater disclosure requirement in trusts, which will include testamentary trusts. So we're trying to be cute on that. Good luck with that. We now have to disclose dispositions of the principal residence, which historically we haven't had to do. I mean, it's an input output. There's no tax, but you know, they'll follow that because maybe if you have something where you're trying to be cute and adding somebody to it, well, the disposition of the principal residence wasn't a taxable event between mom and dad, but now we've added in son, and that's not his principal residence. And what CRA going to determine the value of that interest in? Who knows? You know, a good starting point for an auditor, especially when fresh out of school, would probably be 50%. So you could be looking at 50% of the growth of that since one person acquired it being taxable, when that may not have happened had you engaged in less cute planning with a professional.
Yeah, exactly. Okay, we'll move to the next one. So this is one that tends to drive me crazy. That's why I put our parents, because, you know, our parents, as much as I hate to say it, we're from a different generation where the matriarch of the family was the person who had the bills, the person who looked after things, and absolutely no insult to our clients, I'll refer to my parents. But you know, like right now, I'm collecting my parents' mail because they're in BC and they haven't come back to Alberta yet. And of course, it's driving me crazy when I see like the Shaw bills or the NMAX bills and the gas bills. People put these joint, you know, spend an hour of your time and phone all these people. And if you don't have time, sit with Jeff in our boardroom and change these, because like on an estate, we, for every single one of our clients, have had to sit in the boardroom. And Jeff actually does this kindly for most of our estates, is he'll call with the executor or call with the wife and change all these bills. What 99% of people don't realize is just because you have a house and just because you have gas and a power bill, NMAX doesn't know you. So let's say your parents registered these bills solely in Terry's name, and then all of a sudden Terry's operating and, you know, he's got everything in his name. All of a sudden, well, they don't know Brenda. They don't know who that person is, and they might have had a relationship with Terry for quite a few many years. It could be 20, 30, 40 years you owned that home. And they're not just going to switch that gas over to Brenda. They're going to say, well, you're a new client to us. We now have to charge you a new hookup fee. So sometimes that new hookup fee is $50. Sometimes, for the last ones that we've done recently, is $350 to $500. Plus they take the first month's deposit for you as a deposit because they don't know you and they don't know your credit history. You may also not have a credit history because you have supplementary cards. So that comes down to, again, cell phone bills, because of course people often think, well, I've got a cell phone with my husband passes away. Well, you know what, or in my husband's company. Well, your husband's company now is gone, your husband's now gone, and you no longer have a cell phone. So that's where that usually goes when you suspend that account. They're like, you can apply for a new account, you can maybe switch your number over sometimes not. Same with vehicle registration, we've talked about in the other sessions, is to make that joint. Bank accounts and non-registered accounts is if you know someone's going to be passing away, it's like it doesn't take a lot to go into a bank, and as long as that person has capacity, make that joint with somebody so that they have access to those accounts. If you can't, then yes, it gets turned into an estate account, but that's something to consider. And we talked about in a previous session, just people that have had these direct online accounts. These direct online accounts, they're not someone you walk into. So they're not somebody who you can go, you actually have to send them stuff. And they have, on every estate we've had so far the last 2 years, taken their own sweet time as to when they want to get that done. So if you are somebody that, let's say you might have gotten your TD stuff done in that first few months, and you've closed up everything and you're ready to kind of go, a lot of these times we haven't even gotten a response back from these online account providers. So sometimes, the Tangerines of the world and, West Direct and this and that are not as great as what a staple bank is. And staple banks are used to dealing with this with many people. And I think a lot of the new online accounts, especially the really newer ones, have no idea how to deal with some of this, and they're very difficult, and you have to send multiple letters from the lawyer, multiple requests. A lot of time has to get spent, and you have to realize is that these lawyers' time's on the clock, like Matt's time clock and money clock is running. So and it has taken Matt a lot of time on all of these accounts. So a lot of people think, well, I'm getting 2%, I'm going to go with them. Well, consider what that might be worth later down the road when you do it. You can kind of talk to some of that, Matt.
Yeah, I think it's really important. It kind of gets to that concept of planned and unplanned departures. For certain things, it's ideal to have things separately laid out. And for certain things, and it's one of these things that your own family experience will vary on this. But I think it's a really good point to think about who you're doing business with and how they're able to deal with these sorts of things. Because like Pam said, if we're having a situation where I'm having to get involved, or even if my paralegal's having to get involved, the clock is running, and where a lot of times for state administration, we'll charge on a fee quote for the most part based on an expected level of work that has to be done. But things like this can drive up those costs a little bit. And is it important for that to have had to happen? Well, yeah, because it was the way to get these things done. But a lot of times they're avoidable. And a lot of times it comes up to, like what we were talking about earlier in the presentation, making sure your paperwork matches. Because nothing creates the need for us having to go in and get into a letter writing campaign with a bank or a mortgage holder more than when there's a situation that paperwork isn't up to date, that there's no will, that there's a document from 15 years ago that we forgot to take somebody off title, because they used the discount $500 real estate lawyer who didn't bother to do the cleanup. Situations like that, that's what creates these situations. So it's really make sure your paperwork lines up, because a lot of these things, no matter how they're held, the problems often come when things don't match up properly.
Yeah, I agree. And that's kind of where it comes to also, like mortgages. We always say, a lot of times, again, from an older generation, like usually people now are joint on mortgages. Unless someone can't qualify, then they say, okay, maybe we'll put one on versus the other. I would always have, either a joint mortgage if you have a joint title, or figuring out, like if you're trying to creditor protect, then maybe you have a mortgage on one spouse and you have an agreement put in place that you don't have a problem with dower, which often you don't anyway. But those are the things that you definitely, like mortgage, lines of credit, credit cards. If you have a supplementary spouse and then they're listed almost as a supplementary card and you don't have, we've actually had quite a few clients come to us recently and they're like, oh, I don't have my own credit card. And me and Kelly were like, what? Because we've dealt with them forever and never asked that question. And, you know, we're trying to get better at doing that too, because it's like, you should always have your own credit cards. You should always have your own bank accounts. You should always have stuff like that, as well as having joint, because if you're supplementary, you never earn any credit and you never have any credit, which means when somebody passes away, they don't have to give you that mortgage. And a lot of times it's a negotiation with the bank to get that mortgage. And we did have someone older who passed away, and that was exactly, we were negotiating with the company because of course the bank just came back and said outright, no, she needs to move out. She needs to sell the home and move out, and we need to get rid of that mortgage. And you know, she phoned crying and she tried to deal with it on her own, and it's like, no, let us get involved. And then we were able to get involved. We were able to keep the mortgage and, you know, get it going. But then it's like, she realized she's got to earn a bit of money and there's some things that she needed to do. And it's like, well, maybe over time we're going to downsize that house and maybe get rid of it, because I think that's important when it comes down to it. And always with credit cards, like make sure you have your own, because really when that one person passes away, you no longer have cards. So that's, a lot of people think, well, I still have a $15,000 credit card. You don't. And that's where the insurance payout again really helps you, because you have instant cash and you don't have to start cashing things to deal with it. But all those kind of things, same thing with car loans and leases. A lot of people don't think about that. And it's like, if you have a lease in your business, you don't necessarily own that car. And then all of a sudden we're dealing with companies, or if you sell the company and it's like everything's in the company. Again, if you're not planning that, that becomes a problem if that's your only vehicle. And we've seen that happen where people argue, well, if I'm buying this business, that car is in that business. So, you know, that's always something to think about. The other one that people are often shocked with is CPP. Is people kind of say, well, you know what, my spouse is getting CPP, or they die and they're like, well, I get their CPP, right? You only get a very small percentage of someone else's CPP. So if you're under 60s, you know, you get way less of that person's CPP, and then when you're over, you get a lot more, but it's still not always the exact amount of someone else's CPP. So that's where you want to be aware that if you're living off of a CPP or old age, you don't get your spouse's amount all the time, you get a lowered amount. And so it's like, again, knowing your burn rate, knowing what you actually have is super important, because if you can't exist beyond that, again, that's where insurance plays a really big role to supplement the estate.
Absolutely. And Pam, you brought up a really good point, and it's kind of a sidebar to this, but you know, people really need to understand and appreciate. I call it the, you know, knowing the difference between the circles and the squares. And what that means is, you know, when you look at a net worth chart, usually we'll have individuals as circles, corporations as squares or rectangles, trusts as triangles, or estates as triangles. And the idea is people often will think that because they own their corporation, that they own the assets within it. And so it's very, it can be very problematic, especially if a will tries to move something that's property of a corporation, or like Pam mentioned, where you have the car in the name of the corporation. Then it's not really an estate asset, and who should be using it. And then it becomes a question of, if we're letting somebody else use it, are we now creating a shareholder benefit, where originally the person using it was using it as an incidence of employment, or it was being papered as part of a bonus or a part of their compensation model, but now it's changed. Have we created a tax problem now? I mean, in a lot of cases, people are doing things like that, and they are flirting with the tax problem because it is a benefit that they're not necessarily reporting. But that's the kind of thing that gets exacerbated in an estate point of view, because if we have an income inclusion and we haven't thought about it, that's now tax that's owing by the deceased that wasn't originally there, and creates that liability for a personal representative. So when we're looking at knowing what's personally held, what's corporately held, what's held in a trust, what's held in a partnership. It's very important to know the difference and to plan for that to try to reduce the risk of issues that may come up with your executor later.
Yeah, exactly. Exactly. So we'll go on to the next one. This one's a really funny one because people kind of go, well, you know, I've got one of those, which is great if you do. Keep some things in it, like maybe jewelry, so that if your house gets robbed, your jewelry, your favorite jewelry's in that safety deposit box. Sometimes there's cash that we've seen people hoard in safety deposit boxes, which, you know, is great. But I'm going to put it out there and say, is this really the best place to put a will? And I'm going to say, I'm going to ask Matt just a yes or no answer. What do you think, Matt?
No. Full stop, no. Here's why. So a safety deposit box may not be easily accessible to your executors. And this is very important. If you appoint a professional, they're going to tell you that you can't leave it there. They're either going to have it with them at their trust company, or they're going to have it at the lawyer's office. And the reason for that is that they'll be able to access it. They know where the original is. If you don't, and an original is sitting, and Pam and I have both dealt with this on separate occasions, you may have the situation where a bank won't let you in unless you have the original, but the original's in the box. So how do we get it? Long story short, a very laborious concept which will result in the safety deposit box getting drilled with the executor not present. The lawyer has to be present because it's a formal process through the bank. And if you have, like my mentor was there, he charged $2,000 an hour for his time. And you have that person there. I mean, realistically, he wrote off a lot of that time, but you still have a lawyer there to deal with this. And we're not even off to the races yet for estate administration. We're just getting the will to get started, and all because it wasn't in a safe, secure location that the executor can access easily. And so if you want to keep a copy of that, even then, do so with care. One of the issues is people leave copies in their safety deposit box, forget about it. There's a couple new versions of a will. Then somebody comes out and goes, uh-oh, which one is actually the valid one? It should be the latest one in time, but is it? That could become a question. Somebody could say, well, it's clearly this copy that was kept in the safety deposit box, and this other one, oh, that mean old sister of mine made dad do it, or the new wife made him do it, or whatever. Now we're creating ammunition for a situation that maybe doesn't exist. So very important to keep your original document somewhere that's safe, but also somewhere the executors and your attorneys and agents can get at it in a reasonably timely manner, especially with personal directives and enduring powers of attorney, because those tend to be needed on an emergency basis when they're needed. And you don't want a situation where it's a Saturday night and you need it and it's in a safety deposit box and the bank hours are closed. Because you might be able to coax a lawyer to go down to the office and get it for you. If you have a copy of it at home, and we do 2 originals of enduring powers of attorney and personal directives as a policy for that reason. But you don't want to have that situation where you can't get it.
Yeah, and the banks usually, like in this circumstance, what happened with us is they have to list everything that's in that box. So not only have you lost any privacy that was in that box, the bank has to list it all out under their own security rules, and they also have to have an action as to what's going to happen with it. So if in fact there is no memorandum on some of the jewelry that might have been in it or the cash that was in it, then all of a sudden they see it as residue, and that residue gets to be the last thing that's dealt with. So family can't go visit it. They can't go see it and see if they want it. They can't go see if it's pertinent to anything they're doing. The bank hangs on to it as part of their process. So they have a list. They don't just go, oh, okay, and hand it over to the lawyer. They've now had to drill that box, which now makes it their property. So that's, until the fact of, it still is your property, but, they take it over for the time being until they know what to do with it. So that's super important to know. And yeah, we've had it happen a few times now. So the bank has a process, and they charge for that too if they have to drill a safety deposit box out. Even if people have found keys, they're like, nope, we've got a process. So everybody kind of has their own process with dealing with things. Banks have their own estate team that they deal with as well, and they deal with things a certain way. And it's kind of just really important to just learn to work together, because sometimes they can be really difficult and sometimes they can be really easy. And we've come across both, and in our careers for in the last 21 years, it's been interesting to see who's difficult, because I'm not going to pin anybody to it, but I can name certain banks who are consistently difficult, and I can name certain ones that are consistently easy. So, those are things to think about too, is having that relationship with people too, because oftentimes when you know somebody, it often makes it a bit easier as well. So that's all those things from there. And now we'll go into questions, I think, is our last slide. And we really appreciate everybody attending. Matt, again, thank you for attending today. I really appreciate it. We'll go into some more questions. With our What Matters Most binder, I kind of mentioned there is our What Matters Most binder that we talked about with our estate legacy plans is we have people actually fill out a binder of all their ideas and wishes and what they want, where stuff's located, where you keep your NMAX bill, what is your NMAX account number. We have listings of all of that, as well as your social media, which we didn't talk about today. But again, social media is a really important one that, even if your will has powers to do it, some of the social media accounts still, their estate plan online overrides the will. So, you want to make sure that you have listings of everything you're doing, and making sure that if they have an estate plan that you're looking after it. And that's part of our What Matters Most binder, as well as last wishes of what you might want to see happen that you can tell your family. We've often had family meetings as well, and Matt's helped us with a lot of that kind of stuff too. So if you're interested in getting something like that, talk to us, or getting your wills redone with Matt, obviously talk to Matt with Field Law and talk through us as well, and we'll arrange that for you too. And we'll go ahead with some questions now that you guys probably had some time to type them, or if you want to raise your hand again, we can unmute you and chat that way too.
Thanks, Pam. It's Jeff from the Tower Group. We have a question from James, and James is asking, so now that my will is not in the security deposit box at the bank, do you have any advice or any tips on a good, safe place I can keep that?
Well, we usually say either in a filing cabinet or with a lawyer. If you actually have a good lawyer, the lawyer should be keeping a copy, because no matter if somebody passes and it's a bigger law firm, the law firm will actually keep it for you under somebody else. If it's a small one-man show, that does get to be a concern as to what they did with their files. So if you have it now in your possession, we often say put it in the back of a filing cabinet, let your family know where it is. You could provide the copy to the executor if you would like, and then the executor has it should something happen to you. Or we often say a freezer, a deep freeze is a great place to put stuff. So whether you have an insurance policy, whether you have an important document like a will, if your house was to burn down or you get broken into, nobody usually goes into your deep freeze to check out where your important papers are. But through a fire, it tends to become a safe place to be, as well as some people have fireproof safes in their home. You can certainly do that too, but then someone has to know the combination, because if no one knows the combination, it's about as good as being in a safety deposit box. Matt, you might have some other suggestions.
Those are the big ones. I think it's surprising how often we found original documents in a deep freeze. For that reason, it tends to be pretty fire resistant. Aside from that, yeah, a safe, a fireproof vault in our file cabinet are good options. Your lawyer is a good option, even if it isn't the lawyer who drafted your will. I've been working on a file with a lawyer from another law firm. They don't offer estates, but they had the original in their vault. So your corporate lawyer, if you don't have an active estates lawyer who's willing to do that, they can probably hold it for you. If your executor is a professional like a trust company, they should probably have it, but those would be the best options.
Thanks, guys. Ryan has a question. Ryan's asking, my parents are very stubborn and it's super hard to get any information out of them. I'm very concerned about their estate plan, and I've heard of the concept of a family meeting, but I've never had one before. Can you just let me know what that kind of looks like and how I could set that up successfully?
Sure. I think that would be a whole other topic of kind of how you structure that. But, obviously we try to go in with a lot of people, and we can do that as another session too. But you know, I think having a family meeting is usually discussing things that people want to discuss. If they're really not willing to discuss anything, it's hard right off the bat just to have a family meeting with somebody. But I think to have a conversation about, look at what I've done. The Willing Wisdom Index is also a great index that, you know, people can often get really excited about it if they've done it themselves. And then they can show their mom and dad, look at, I've got 20% on this, man, I need to do my own estate plan. And I know having that conversation, even, you know, with my parents who were also very stubborn, initially it was like, okay, you know, let's go through that plan. And you know, all of a sudden people start looking at their own plans because it's like, well, I haven't done that Willing Wisdom Index, I'd like to do it. And I tend to find people either get really excited when someone else is excited, or they get really defensive. So you get one or the other, where, you know, depending on who they are, they either get really excited with you and start going, wow, I gotta, you know, think about this myself, or they get really defensive and go, oh, I haven't done anything, so I'm gonna just run away. That's a possibility too. But sometimes it's just saying, hey, we can give you a second opinion service for all of us, and you know, they can take a look at it, especially if I'm going to be executor. And sometimes the parents will come right out and say, you're not executor. And then it's having the conversation of who is and what happens if something happens, what's my role. And I think sometimes that's a really interesting, fun conversation to have. And you might have some other ideas, Matt.
No, I think those are really good. My main comment would be it's very important that a family meeting doesn't become an intervention. If somebody isn't really wanting to talk about their plans, you know, it's going to be very hard to get them to do that in a formal setting in front of lawyers, accountants, planners, and professionals. You know, what works quite well is horror stories of bad estates, but what also works well are stories about when estates worked out well. You know, and like Pam said, mentioning, you know, doing your own estate plan, or you know, seminars that you've attended, you know, maybe from Tom Dean's or whatnot. But that tends to work quite well because you know, especially the older generations, like the golden generation, they're incredibly secretive about their finances, which creates a real big problem in the future because you get a whole generation of unprepared beneficiaries, or you get beneficiaries who got debt happy in anticipation of receiving an inheritance that isn't coming. Big thing to point out generally is, you know, adult children in Alberta aren't entitled to an inheritance at all. So sometimes, you know, you could have a situation where a family is choosing not to give anything to their kids. They may be going directly to the grandkids, maybe going to charity, maybe going to, I worked on a file that is a published decision. I didn't attend, I just kind of helped out the litigator, where the parent completely wrote out the kids and left it to his friend who happened to be his banker because that was the only person who talked to him. So you don't want to come in too aggressive on that sort of thing. But, you know, it's one of those things that's a gentle topic. And I think it's important to maybe, you know, be able to point out, if you are the executor, you have a right to not go in blind because you have that right to renounce upon activation. So it's a two-way street on that. Is, you know, somebody doesn't get to just come up with a plan, whether it's a good plan or not, just toss you to the wolves and hope all is going to work out well in the end. I mean, if you know, coaching is a really important aspect of this. So it's one of those things. Every family is a bit different how you view it. Some work better with the carrot, some work better with the stick. But usually, you know, introducing the topic in a soft way is the best way to get the ball rolling.
And I was going to hold up my phone too, because this is actually one of Matt's mentors and someone that we've worked closely with. Dennis Nerland also wrote a book called Family Fortunes. It actually is on Amazon.
Ghost written some clauses in there.
Exactly. He wrote a book that's $9 on Amazon under Kindle, but it's kind of a book on how to pass on wealth and pass on things to your family. And you know, being one of the top tax and state lawyers out there, you know, I found sometimes that book, just giving it to people to read and kind of, you know, makes them contemplate their own situation too. And he's got some good stories in there too. So I think, yeah, sometimes people like to read too, and just likes to read about what does go on. So that's
Thanks,
awesome.
Matt. We have a comment from Elisa that's pretty interesting. She says her son is taking the paramedic course right now, and they say to always look for the personal directive on top of the fridge. So more of a comment than a question, but interesting to hear. And that's about all we have for questions today. Thanks everyone for attending. If you have any questions that come up after the fact, you can always email us at info@thetowergroup.ca. Pam, I'll pass it over to you and let you end the seminar.
Yeah, thanks very much again. And yeah, Lisa, thanks. That's a great idea. We've never heard on top of a fridge because it usually gets pretty hot there. So to have documents sometimes is a bad idea for a fire. So I'm surprised that they would do that, but it's interesting that they do. So I was gonna say too, a lot of people don't know, which I've told a lot of clients, is there's what's called ICE. So ICE, which stands for in case of emergency. There's those apps on your phone. Apple automatically has it as part of your screen, your main screen. That's also, I'm noticing now, a lot of the ICE applications actually have on it, where's your personal directive on there, which is kind of interesting that that's starting to pop up now, but it kind of gives them, and I know a lot of firemen, you know, and paramedics look for that ICE app in your phone when they get there, because they can actually access that emergency contacts on your phone as long as you open it, which is part of that app. It'll say, do you want it accessible? Then if you got in a major car accident or something was to happen to you where they needed to get access to your personal directive, they actually can get all your personal information, who they should contact, who they should phone, which, you know, could be things like your executor and things like that on it. Alberta Healthcare too, which I know a lot of lawyers don't trust. Matt can kind of comment more on that. I know a lot of lawyers don't say put it on there, which I have not myself. But when you go in for surgery, they usually will ask you, like when I've had all of my surgeries, they've asked for a personal directive to be sent to them. And they ask for it the day you actually get admitted as well. But if you're not admitted under something that you've planned, they obviously usually like to have them, but Alberta Healthcare actually has a system that they can actually keep them on file so that any physician in the province actually has access to it should they need it. And you can kind of comment to that, Matt.
So I don't have any sort of strong opposition to AHS having that. I don't think that's necessarily a bad thing, because you know, in a crisis situation, in a quick situation, you know, doctors need to be able to do what they need to do. They've got that power under the act, but once, you know, the situation has subsided a little bit, they want to be able to go get instructions from the right person. And that in the first instance is the agent under the personal directive, because you may have gone out of your way to make sure that your next of kin is not the decision maker. And if a doctor can't find that agent under the personal directive, they're going to that next of kin. So, you know, in situations like that, it makes sense. Also have to echo that I'm very surprised about having a document on the top of the fridge. That seems like asking for trouble, having it either roll in behind, being a fire hazard. But that's interesting that that's what they're teaching. I would assume they would teach them to look in freezers, to look at desks, but not the top of the fridge. That's interesting though.
Mm-hmm. Well, thanks everybody for your comments. Do we have any other questions, Jeff, or we're done for the day?
That's all we have for today, Pam.
Perfect. Well, thanks everybody again for attending. Thanks, Matt, for all your great advice.
Thank you for having me.
All the way along. Again, anyone who wants to contact us, they can contact us. We're happy to talk to you about it. Thanks so much for attending.